Hello, everyone. Welcome back to the LAOT Podcast. I'm Arnav Mathur, and today we're going to talk about something that goes at the very heart of Indian constitutional promise and what the Indian state has chosen to deliver. Here's what has happened so far. In 2014, the Supreme Court in National Legal Services Authority versus Union of India recognized transgender persons as a third gender, affirmed the right to self determination of gender identity as a fundamental right under Article 21 and declared gender identity could not be made contingent on medical. In 2019, the Parliament passed Transgender Persons Protection of Rights Act, ostensibly to codify these rights. In October 2025, the Supreme Court returned to the subject in Jane Kothari versus Union blamed the government for its decade of apathy in implementing transgender rights, recognized reasonable accommodation as a constitutional obligation on both the state and private employers, and constituted an advisory committee to close the gaps in the 2019 Act. 5 months later, in March 2026, before the advisory committee had even submitted the report, the government introduced and passed the Transgender Persons Amendment Act of 2026. The bill passed in Lok Sabha, Rajya Sabha, and received presidential assent on March 30th. It removes the right to self-identity. It narrows the definition of a transgender person so drastically that it excludes trans men, trans women who have not undergone a surgery, and genderqueer individuals. It reintroduces a colonial era term of eunuch. It mandates that medical institutions report gender affirming surgeries to the district magistrate, and medical groups have condemned the act as scientifically inaccurate and medically unsound. Two members of the statutory National Council for Transgender Persons have resigned in protest. To help us think through all of this and make sense of what has happened, we are joined today by Senior Advocate Jayana Kothari. Ms. Kothari is a senior advocate who practices before the Supreme Court of India and is founder and executive director of the Center for Research Law. She holds a BA LLB degree from University Law College and BCL from the University of Oxford. She was awarded the Dr. D.C. Pavade Memorial Fellowship at Cambridge, argued some of the most consequential constitutional cases in the last decade, including the Section 377 in Navtej Singh Johar, the challenge to child marriage and exemption in court, and the challenge to the law. Ms. Kothari, thank you so much for joining us today.
Thanks for having me.
Now, before we get to the 2026 amendment, I want to establish the baseline that we are working with. The NALSA was decided about 12 years ago. At the time, it was considered as a landmark judgment since the Supreme Court recognized trans persons as a third gender and grounded gender identity in the fundamental right to life and personal liberty. Now, from NALSA, we have seen a gap that has emerged from what NALSA promised and what has actually materialized on ground. What do you think went wrong between the decade from NALSA to Jane Kothari?
So, NALSA, you're right, was and is a landmark judgment that recognized the rights of transgender persons and recognized the right, most importantly, to self determination of one's gender identity. Now, while NALSA was implemented to a fairly reasonable extent, because we have many judgments that have actually given relief to trans persons on the basis of NALSA and NALSA's guarantees. But some of the things that didn't follow NALSA, the most important was the Transgender Persons Protection of Rights Act 2019. And if we look at the act, the way it was enacted, it recognized the right to self-determination of gender identity, yes,
Yeah.
and guaranteed the right to be declared as a transgender person, but in guaranteeing the right to declare one's gender identity as male or female, which would be to change it from transgender to male or female, the Act still required the submission to the district magistrate of medical records. Now, to some extent, that was diluted by the rules that came out, because the rules expanded medical intervention or medical records to even mean counseling records or hormonal therapy related prescriptions. But the core guarantee of NALSA is that one can self-determine or self-identify their gender, and which is not dependent on any kind of medical intervention. So, the initial round of challenges that were made, or the initial round of critiques that were made to the Transgender Persons Act 2019 was that this very requirement of a two-step process of first having yourself declared as transgender, for which you don't need medical evidence, and then a second step process of having male or female gender identity recognition, which requires medical evidence, is actually not in the spirit of NALSA, and due to which a lot of members from the trans community have been unable to get their gender identity certificates.
Understood.
So, we see a large gap that even after NALSA and the passing of the 2019 Act, a lot of members of the trans community were unable to get their legal recognition certificates, their name and gender change, though the Act and NALSA says you're entitled to legal recognition of your gender identity, which means that you're entitled to get your gender identity recorded in your legal documents. But and the Transgender Persons Act also mandates that. But in practice, it wasn't easy. So for people who had to get their name and gender changed in, for example, their educational documents, the education department, universities, boards would not do it because they were not aware that they were mandated to do it. Then you have to go to court. How many can go to court, right? How many have access to lawyers and to the means to go to court? Those who wanted, for example, the Aadhaar card, PAN card, passport, even those were not easy. Some things then started rolling out, not all documents. So those were really the big challenges for people to get their gender identity legally recognized and have their name and gender recognized and recorded in their legal documents.
Understood. I think the whole idea of this two-step process that you discussed, and of course the implementation of it was a different question. But coming to the question of self-identification, the 2026 Act, in one of its most consequential changes, removes or abolishes this idea of self-identification. Section 4.2 of the 2019 Act, which recognized a person's right to self-perceived gender identity, has been deleted. And in its place, the Act creates a medical board, which is to be headed by a chief medical officer or a deputy CMO, whose recommendation is now a precondition for the district magistrate to issue a certificate of identity. Can you walk us through what self-identification means, and in practical terms, why is this a relevant issue, and why the medical model is something to be critiqued or to be looked at as harmful?
Yeah, so the Amendment Act, removes the reference or the guarantee that you'll have a right, all persons have a right to self-perceived gender identity. So that is removed. The definition of transgender persons is highly curtailed because transgender persons now, under the amendment, would only include persons from socio-cultural identities and persons with intersex characteristics. And then it still has the provisions of applying. It still has the two-step process that the first you can apply for for a recognition as a transgender person, and then it has the second step of male or female. What it does, it doesn't replace it with a medical authority.
Okay.
It adds a medical authority to it. So the section initially, what said was that the district magistrate would, look at the documents of medical documents and then give you the, gender identity certificate. Now it says the district magistrate, after examining the recommendation of the authority, this
Yeah.
new medical authority, and after taking assistance of other medical experts. So then who are these medical experts, right? So basically it gives, one is a lot of discretion to the district magistrate, because it mandates that the district magistrate will also examine the recommendation of the medical authority and can also go to other medical experts. And in fact, it also says that the medical institution where the person has undergone surgery should furnish details of that surgery directly to the district magistrate. Now,
Yeah.
what this does is that the one is, of course, the issue of surveillance and privacy, but
Yeah.
this, though there was the requirement of medical documentation or medical intervention to be provided earlier, that was diluted to a fair bit by the rules, which to mean that medical intervention could be anything. It could be hormonal treatment, it could be counseling. It needn't have to be surgery, because surgery is the last stage,
Yeah.
and the most intense stage of medical intervention. But here, because it says that the medical institution where the person has undergone surgery shall furnish the details, it kind of presupposes that for gender change or recognition as male or female, you have to have had surgery,
Surgery done.
and that surgery should have been reported. So all of this makes it even more medicalized, and that is therefore against the mandate of NALSA.
Yeah.
And the whole kind of definition of self identification. And, if the, and even these sections are in a way contradictory, because if on one hand you say that they are only, transgender persons are only those from socio-cultural identities and not trans men and trans women, then how are we going to recognize male and female, right?
Correct.
So it is in a way self-contradictory, but yeah, so these are the changes made, which kind of then make it put a lot of onus on the medical institutions, give a lot of discretion and responsibility to authorities, not to the person, which NALSA kind of located self-determination in the person themselves and not to an external body.
Understood. And I mean, before we move to the definition of transgender persons, I wanted to understand what the justification is, because the justification that is officially given is that the existing definition was vague and it made it difficult to identify genuine beneficiaries of welfare schemes. They argued that it was not compatible with the other statutory provisions. How defensible is it? Because like you mentioned, this right, if you need Aadhaar card or a ration card or any government proof, you would need to undergo this particular law. How defensible are the justifications that have been passed here?
I don't think the justifications are defensible, but the same claims or justifications have been always raised, even before the 2019 Act was enacted, and right from the beginning. And the thing is, these kind of claims are not new to the Trans Act. It has always been the case from the government on many different groups of people, that how do you ensure that the beneficiary is the real beneficiary and not just pretending to be one, to get benefits. And, it has been done in the instance of caste, and now in the transgender persons or the trans communities issue. From the beginning, even before the act was enacted, many states had, welfare schemes, pension schemes, though very meager, but still had certain benefits for members of the trans community, and many of those benefits are still there now. And of course, Karnataka is the only state that provides reservations in employment.
Yeah.
But other states provide, you know, pension schemes, some kind of livelihood schemes. Then you may have the insurance, medical insurance schemes. And so the claim made is, with this self-determination, because a transgender card you can apply with a self-declared affidavit, right?
Yeah.
Or anybody can apply and get an affidavit. And if anybody can apply through an affidavit and get a TG card. And therefore, how do we know that you're really a transgender person? And the kind of framing is that only members of the transgender traditional communities, which are the socio-cultural identities, Hijra, Kinnar, and other communities, they are the real transgender community.
Correct.
And so then let us go back to that. And then we don't want trans men, trans women, genderqueer persons, or anything else, or any other kind of gender minority, which comes under the transgender umbrella. And it just therefore is intersex persons, because it's again seen in a very medicalized way, and people from socio-cultural groups.
Correct. So
And
the
that's
acts
the base for which, or that's the argument for this amendment.
understood. And it seems to be that the definition itself has now been reduced, where the act is only supposed to protect socio-cultural identity. And uh, earlier, I mean, now it has removed the explicit inclusion of trans men and trans women and genderqueer persons. And it's replaced with a closed set of categories. The socio-cultural identities that you mentioned, Hijra, Kinnar, Abani, Yokta, and the intersex conditions. Now, the definition that is retained for trans women and trans men is they're only recognized if they have been forced to assume a transgender identity by mutilation, emasculation, or castration. What are the legal and practical consequences of this exclusion from definitions, and how would that play out in practical terms?
I mean, we'll have to see in practical terms how it plays out,
Mhm.
because the earlier definitions of trans men, trans women, genderqueer persons are not there.
Yeah.
And so the actual, the act has just been notified, and we'll have to see how it plays out in practice. But from the reading of the law, it would mean that if you are a trans man or a trans woman, but who is not part of a socio-cultural identity of the four, of Kinnar, Hijra, Ravani, Jogta,
Yeah.
because even the social cultural identities, there are many more in our country, and those are also not included. But if you say even these four,
Yeah.
then you are actually not falling within the definition of transgender person. And then the question would be, how do you prove that you're a person from any of these socio-cultural identities?
Correct.
How do you prove that? Do you need a certificate? Do you need someone from the community to vouch for you? Do you want someone to co-sign your affidavit? I don't know. So for example, in the early days of the post-NALSA litigation, which and even before the enactment of the 2019 act, in some of our early transgender rights litigation, where there were transgender welfare boards in many states, and they were issuing transgender cards, identity cards, which would
Yeah.
enable trans persons to get relief, rations, things like that. There
Yeah.
also, in our litigation, state governments would raise the question that how do we know that they are real transgender persons? And the question then was, okay, we know members of the socio-cultural identities. So for example, in Tamil Nadu, in some of the litigation in Tamil Nadu, the the what are the cultural identities uh, in Tamil Nadu, Tirunangai. So they had the boards, And there, the government would say, no, we want members of the socio-cultural community to actually identify and
Hmm.
confirm if a member of the trans community comes to apply for a card, they should confirm that yes, they are indeed a member of our community and they are a trans person, you know.
Yeah.
But and so these same arguments, these are not new arguments. These were there even 15 years ago.
Hmm.
And you know, how practical is it? What if you don't get someone from the community? And you know, what
Hmm.
does it mean to be part of that community? What if you have an urban kind of grown person who's not been part of a traditional socio-cultural identity? And then what
Hmm.
happens? And then what do you mean by a eunuch? There's no
Yeah.
definition. It's a very it's a stigmatizing term, you know.
Yeah.
So yeah, and how it is going to play out, we'll have to see. But it looks for them, you know, if you read the law, it would mean that they will not be covered.
Understood. And I mean, the two issues that you point out, that firstly, of course, it's an exclusionary definition, an exclusionary law, which is limited to only a certain set of identities. But there are issues even within that where, firstly, it's limited to only certain socio-cultural identities, where there are multiple different uh, socio-cultural groups that have been excluded. And then how do you define how what are the criteria, who gets to decide, is something that the law doesn't say, and I think it could become an issue as well. And the one thing that you mentioned was that how the the state governments or any government's anxiety is that how do we prove that this person is transgender who can avail this particular scheme, and the answer somehow comes to be medical certification. But medical certification for gender identity has been a long and contested history, even internationally. The WHO removed gender incongruence from the chapter of mental disorders in ICD 11, and countries like Argentina, Ireland, Denmark have moved towards a self declaration model. Now, this particular amendment act moves towards the opposite direction, and there have been medical groups who have already condemned this as scientifically inaccurate and medically unsound. What do you think is the relationship between law and medical science, and when is it legitimate for law to require such a medical involvement for a precondition to a perceived identity?
Yeah, I mean, you know, obviously you know, from NALSA, there has been a complete move to not have medical intervention as a criteria for gender identity determination. But despite that, the law has it, and now it has made it even more stringent,
Hmm.
you know, the amendment. And therefore, that becomes a big challenge because even if you look at you know, whatever the justification may be,
Yeah.
uh, even if you look at the medical profession, medical institutions, and medical professionals, you
Hmm.
don't have institutions or medical professionals who are familiar um, with the issues concerning transgender persons. We
Hmm.
have members of the community themselves saying that the medical community needs awareness and education.
Hmm.
There's been a big demand that medical curriculums
Hmm.
be amended to include many of the transgender community's concerns. So, you know, when the medical authorities and medical professionals themselves have such a long way to go, to
Yeah.
put so much responsibility in the hands of medical authorities is actually, you know, really putting the determination in their hands
Yeah.
of members of the trans community. And of course, the other thing is that the core of the trans movement has been a claim for self determination of
Okay.
gender. And I mean, that's the core claim, right?
Hmm.
Where, and so any kind of medical authorities determining or deciding
Hmm.
their rights and entitlements is itself antithetical to the claims for equality of members of the trans community. So that is, of course, the core issue.
Yeah. Understood. And I think it's important to always realize what the core argument and core thesis behind the entire movement is, which is self-identification. And the more legalities and interventions that you put through medical science into it, which of course has its own problems of education and practitioners not being able to determine how it should work, is something that should be looked at. Now, coming back to the amendment itself, the third significant change that it has brought is the criminal provisions. The Act creates graded punishments for kidnapping and causing grievous hurt to force a person to assume transgender identity. And it adds punishments for forcing a transgender person into begging or bonded labor. These are protective provisions, so they're okay to that extent. But what I think is that they could also lead to criminalization of the transgender community by encoding the assumption that transgender identity is something that is imposed by coercion. How do you read these criminal provisions?
Yes, those are some of the concerns. And so, if you look at the amendment and the new criminal offenses that have been added, it
Yeah.
says anyone who kidnaps or abducts any adult person and causes grievous hurt by mutilation, emasculation, castration, amputation, surgical, chemical, or hormonal procedure with
Yeah.
the intent of compelling such person to assume or present a transgender identity against the will or consent of the person by force, allurement, deceit, undue influence, can be punishable with 10 years, or again kidnaps, and the same thing to a child, which
Yeah.
can be, punishable for up to life.
Yeah.
And then you have anybody who compels a person by force, threat, coercion, allurement, deception to present, dress, or conduct themselves as a transgender person, or employs or causes them to engage in begging, solicitation, servitude shall be punishable for, up to 10 years. And again, the same thing for a child. Now, see, what does this mean? If it can be used in any way, I mean, if someone joins, for example, let's say someone joins a, socio-cultural group, someone
Yeah.
joins a hijra community,
Hmm.
then the fear that the members of the community really face is that if someone comes to us who's an adult, who we can even leave out a child for the moment, someone comes
Yeah.
to us who's an adult, who's been thrown out of home and who has the we want to really, and they want to join the community, and we want to help that person as being part of the community. So then even the fact of you when you if that person dresses or presents or conducts themselves as a transgender person, that can be seen as if they're being forced into it, and then that's punishable with 10 years. So any kind of, so the community is extremely afraid that this kind of, when do you say that you're forcing someone, or someone is being forced to present themselves, as a transgender person? It could be a trans community group, it could be a support group, it could be a
Yeah.
crisis intervention group, it could be anybody, So many of those things, supposing a group assists someone in getting some medical intervention,
Yeah.
say they raise funds for it, then even
Hmm.
that can come, right? That you caused grievous hurt by surgical, chemical, or hormonal procedure,
Yeah.
So all those things are extremely risky because it's put in a very broad way, and it can actually potentially even put the trans community at risk.
Understood. And if you read the two provisions first of the definition of transgender alongside these criminal provisions, you have a very structural issue. So the definition is socio-cultural, so you have to be a part of that group. But for that group to accept you, now there's a disincentive that if we accept them or if we try to help them in certain ways, then we have a fear of being penalized for it.
Yes,
So
yes.
it leads
Yeah,
to
it is
this.
contradictory. Yes, I mean, and if this is a act supposed to be for the rights of transgender persons, then some of these provisions put the members of the community at risk.
Correct. Right. And if we were to call it on one hand a act for the protection of transgender persons, the self-identification provision clearly negates that. If we look at it only to say that okay, this is only protecting the socio-cultural identities and groups, even that through the operation of these criminal provisions seems to weaken. So from both angles, it seems to hurt the community more than help it in any way. Now, what I want to do is turn to theory, because some of the questions that we're talking about is about how law thinks about gender. Now, I've read Judith Butler, and the argument that she tries to make is that not only is gender a social construction, but sex itself, which we take as biological reality, is constructed through discourse and through society. And she has argued that the very distinction between biological sex and social gender is a product of cultural norms. It's not a pre-given truth of nature. What does this argument mean for how law should think about gender identity at a broader scale?
I mean, if you look at, I would go back to NALSA,
Yeah.
and in NALSA, while not referring to Butler, but then in NALSA, there was a clear recognition that we have to move away from the binaries.
Hmm.
Of course, gender binaries, and they looked at gender as being a social construct. But even
Yeah.
if you want to say sex binaries as well,
Yeah.
because if you look at even intersex characteristics, so therefore you can say move away from sex or gender binaries, and
Hmm.
that was the premise of many of the observations and guarantees in NALSA, that we move away from the binaries
Hmm.
and then open up a space where gender identity is not determinant or not determined by any medical intervention. It is a psychological determination by a person
Yeah.
of their gender identity, and which could be male, female, transgender, and they've even made observations of other.
Hmm.
So you can have a gender queer, or a male, female, or any other identity that one may decide. So
Yeah.
there is so these this basis and this binary has been, we have moved away from it.
Hmm.
And how do we ensure that the law also kind of keeps that open, and
Hmm.
doesn't again confine to binaries or even fixed determination of gender identity?
Hmm. Understood. And I mean, to some extent, it's interesting to see that intersex persons have been mentioned within the act. So, on one hand, they have uh, they 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 see biological sex as a fact that must be determined by the medical community, but they also recognize uh, that biological sex does not always correspond to a binary, and intersex persons are also recognized within the act. So there are these inconsistencies within the act's logic itself. Now, let me ask you to reflect on your experience from being a constitutional lawyer advocating for the transgender community across this arc. We've seen that whenever a judgment like NALSA comes and then the Supreme Court recognizes a right, the Parliament ends up legislating in a way that ends up diluting it. The community then goes again to the court, and then the cycle keeps on continuing. So, how do you understand the relationship between law and politics in a context where legislature can move this fast and litigation, of course, takes more time?
It's all constitutional litigation or rights litigation has always been like this.
Hmm.
You move 2 steps forward, move
Yeah.
3 steps back, again you move 1 step forward, 5 steps back. And
Hmm.
that, I mean, of course, in transgender rights litigation, we've seen how, prior to NALSA, there was nothing.
Yeah.
There was the fight for decriminalization of Section 377, because
Hmm.
that was the biggest stumbling block,
Yeah.
and that fight took so many interesting turns, right? It went from the Delhi High Court to the Supreme Court, back to the Delhi High Court. Delhi High Court gave a favorable judgment. Supreme Court overturned it, sending it back to the Parliament. Then we got NALSA. Then we got Navtej.
Yeah.
So we have, even within the larger framework, we've had, NALSA gave, the push for more litigation.
Yeah.
It gave the push for fighting for decriminalization of Section 377, which led to it. That gave us further further support for more litigation. Then the
Yeah.
law comes. The law takes some steps back. Then you have an amendment that goes several steps back. So I think, and there is social change as well. We saw that, with the Navtej decision, and after NALSA, there has been a huge social change in which there has been at least some move to recognize gender identity and sexual orientation. It's not complete, but there has been some openness to it. So I think all of these things, as a constitutional lawyer, you see that, some things are determined by time, some are determined by changes in the law, then how courts intervene or not, and then changes on the ground. So it's not new. We have to, keep fighting these things, and always be ready for newer things that will be thrown.
Understood. Thank you so much. I think one key takeaway from this entire conversation is that it's a constant battle, and the challenges, of course, the law that we've analyzed, try to make sense of. There are elements of it that are not new. These are arguments that have not been made for the first time, but the fight continues.